Feminists generally take the line that it's basically a man's world, and women are always potential victims, especially in the realm of sexual assault. The reality is that if you look at a bigger picture than we usually get in the media, women have far more rights than men, and men are victims in ways that are never publicized or even acknowledged. The critical test in law for sexual assault seems to be the question of whether the person claiming victimization knew enough about what she or he was getting into to form a reliable basis for consent. Campuses, we are told, for example, are a hotbed of rape culture because drunk women are considered too impaired to give consent. But men who are drunk and pressured into sex with women, we know this does happen frequently, are almost never considered to be victims of sexual assault. Recently, we were introduced to the term stealthing. Stealthing is where a woman agrees to sex if her partner uses a condom, and if he removes it during the sex act without her knowledge. Alexandra Brodsky, a research fellow at the National Women's Law Center at Yale Law School, has written a paper for the Columbia Journal of Gender and Law, arguing that stealthing is widespread, gender-motivated sexual violence rooted in male supremacy and perpetuated by men who justify their action as a natural male right. According to Canadian law, stealthing is a form of reproductive coercion and has been tested in law. A Toronto man was convicted of sexual assault in 2008 and sentenced to 5 months in jail for removing a condom during sex against his partner's express instructions. And in 2011, a Nova Scotia man was sentenced to 18 months in jail for poking holes in his condom in order to impregnate his girlfriend so she wouldn't leave him. The Supreme Court upheld that decision in 2015. But is sauce for the gander also sauce for the goose? Consequences for stealthing are not equally applied to men and women. To my knowledge, and as well to that of a lawyer who follows such cases that I consulted, no woman has ever been imprisoned or even charged with reproductive coercion for assuring a sex partner she was using birth control when she wasn't. Nobody has ever referred to this act of deception as female violence or an act of female supremacy or a woman's natural right. When women stealth men, the man is not considered a victim of sexual assault in law. If a woman is made pregnant against her consent by a man's stealthing, she can have an abortion, and he cannot prevent her. If she gets pregnant against his consent by her own stealthing, he cannot demand that she have an abortion. Well, of course, the demand would be useless in any case, since legally it is always the woman's decision, but even to ask would be considered a gross cultural crime in our society. Moreover, when a child is conceived as a result of a woman's stealthing, her deceived sexual partner, who I think can reasonably be called a victim here, is liable for child support, which can be claimed retroactively and even if the man never knew in the interim that he had fathered a child. Far from receiving recompense for his victimhood, he is penalized for it. But women get away with all kinds of irresponsible behavior. A woman who drinks heavily or continues drug use during pregnancy, causing impaired fetal development, is never penalized, even though the cost to society of fetal alcohol syndrome in children is enormous. On the other hand, if a man causes injury to a fetus through domestic violence, he can be held civilly and criminally responsible for damages, because, of course, fetuses are deemed the mother's property. Women also have the right to entrap men into fatherhood for children that they have not fathered. DNA analysis reveals that about 15% of children have been fathered by men other than their mother's official partner. Yet paternity fraud cannot be used as an excuse not to pay child support. As long as a man is in residence and performing a fatherly role, the mother is entitled to child support from him, even if she and the child are being supported by a new partner, and even if the new partner is the biological father of the child. Stealthing is a confusing and vaguely defined concept. It also opens up a Pandora's box of possibilities where even pillow talk could be considered a form of sexual assault. For example, at a community lecture in Lethbridge, Alberta, according to a lawyer who was present, a Crown attorney and a police officer suggested that if a teenage boy were to tell his teenage girlfriend that he loves her or wants to marry her in order to get her to have sex with him, that could be considered sexual assault. Now, in fact, there is no case law to support such an idea, but it does show that when the concept of consent is the issue, people in authority tend only to consider women as potential victims. But let's say a teenage girl inveigles a teenage boy into sex by telling him she's unattached. In fact, in my hypothetical scenario, she is actually going steady with a very jealous and possessive football player that any other potential sex partner would legitimately fear retribution from, on which account he would have withheld consent to sex with the football player's girlfriend. Wouldn't that be stealthing, and therefore a form of sexual assault, according to Ms. Brodsky's logic? It's not morally any different from a boy lying about a marriage promise, but I doubt that such an example as a warning to girls would have occurred to the Crown attorney who warned the boys not to lie. Removing a condom without permission or knowledge of the partner, or poking holes in a condom, is certainly unethical. Lying about birth control is also unethical. Reproductive coercion is a serious matter, but let's not call male stealthing sexual assault if we are not prepared to call women's stealthing the same. And if women are guilty of sexual assault in deceiving men into unwanted reproduction, then those women should be burdened with the punitive consequences for their action that are presently being borne by their male victims. For source material and a more in-depth exploration of this subject, I recommend former Canadian family law lawyer Grant Brown's excellent book, Ideology and Dysfunction in Family Law. Thank you for watching. To see more Rebel videos, please click subscribe.